Navigating student discipline, empowering families to advocate effectively. Applicable laws. Section 504 of the Rehabilitation Act and the Individuals with Disabilities Education Act. What is the Individuals with Disabilities Education Act? It's a federal law that supports special education by making sure students with disabilities have a right to a free, appropriate public education, a FAPE, to further opportunities in education, employment, and independent living, and making sure students have the right to services that are designated to meet their unique needs. What is Section 504 of the Rehabilitation Act? Section 504. It's a federal law ensuring children and adults have the right to equal access to education, employment, health care, and community services. It applies to any entity, organization, or agency that receives federal funding. So, what is a suspension or removal? Whenever a school removes a child based upon the child's violation of school policy is considered a suspension or disciplinary removal. For instance, a suspension from the school bus may be considered a suspension from school if transportation is a related service under the child's individualized education program and the district does not provide alternative transportation. If the student is removed from the classroom but not the school, it is not considered a suspension if the student has the opportunity to continue to appropriately participate in the general curriculum, receive the services specified on the child's IEP, and participate with non-disabled children to the same extent. If the school asks the parent to pick their child up from school because of their child's behavior, this may be considered a suspension. What if I believe the misconduct was a result of my child's disability? The Individualized Education Program, the IEP team, should consider what they know about the child and their disability and ask if it seems like the misconduct is connected. For example, a student with ADHD is said to have poor impulse control and may respond abruptly to a situation without consideration of consequences or alternatives, and therefore may be considered related to that child's misconduct. Can my child be suspended if they have a disability? Under Colorado law, for students in early childhood education programs through the third grade, suspension from school is reserved for only the most severe behaviors impacting staff and student safety. For how long can my child be suspended? Under Colorado law, schools can suspend a student grades 3 through graduation for discipline infractions for 10 cumulative or consecutive school days or less. However, the school must conduct a manifestation determination meeting within 10 days of a decision to change the student's placement. A suspension lasting longer than 10 days is a change in placement. Once your child has received the 11th day of a suspension, the school must provide your child with appropriate special education services under the IDEA. What kind of notice should I receive if my child is removed from school longer than 10 days? If the school decides to remove your child for longer than 10 days, it is considered a change in placement. You should receive prior written notice regarding that decision in case you would like to dispute it. After receiving notice, but not longer than 10 days after the decision to change the placement, a manifestation determination review meeting must be set to determine if the disability was related to the violation. Once a date for a manifestation determination review meeting is set, you should receive notice, including the purpose of the meeting, a mutually agreed upon time and date, a list of who will attend the meeting, and a notice to the parents that they can bring others to the meeting. What is a manifestation determination review meeting? Before a student is suspended or expelled for more than 10 days in a school year, the parent, student, if appropriate, and relevant members of the IEP team must meet to determine whether the misconduct was a manifestation of the child's disability or was it a result of the school's failure to implement the IEP or the 504 plan. If the behavior was a manifestation of the disability, then the child may not be expelled. They can return to school or whichever placement they were removed from, and they may receive a functional behavioral assessment, a behavioral intervention plan, or the IEP team may review or modify the current behavioral intervention plan. If the behavior was not a manifestation of the disability, your child may be disciplined in the same manner as a student without a disability. If your child is eligible under IDEA, the school district must continue to provide appropriate educational services. If your child is eligible under Section 504, your child may be disciplined in the same manner as a student without a disability. What if I disagree with the outcome of the manifestation determination? If your child is eligible under IDEA, you can request an expedited due process hearing. Send this request to the Director of Special Education for the district in which you are enrolled and to Colorado Department of Education, which is located at 201 East Colfax Avenue in Denver, Colorado. Under Section 504, the complaint process is a little different. You can attempt to resolve the issue informally with the school by meeting with the school's Section 504 coordinator. You can file a formal grievance with the school. You can submit a written request for a due process hearing to the school's Section 504 coordinator outlining the dispute and a proposed solution. And you can also file a complaint with the Office of Civil Rights with the United States Department of Education if you believe the school has discriminated against your child based on their disability. Special circumstances. All students with disabilities that are out of school for longer than 10 days have a right to a free appropriate public education arranged by the school. However, there are special circumstances where a school district can remove a student for more than 10 days, such as when the student is in possession of a weapon, if the student uses, possesses, or solicits the sale of drugs, or if the student causes a serious bodily injury. Then your child can be placed in an interim alternative educational setting for 45 school days. Things to watch out for if you feel like your child's rights are being violated. Keep track of suspensions. A suspension is any time your child is sent home, and this could be due to behavior. Make sure the school is conducting a functional behavioral assessment and developing and implementing a behavioral intervention plan to address problem behaviors. A behavioral intervention plan, a BIP, should be designed to be able to identify the problem behavior and replace it with a positive behavior so the problem behavior doesn't happen again. Students with disabilities are at a much higher risk to be disciplined for an action that may be a part of their disability. Access the student record every time your child gets in trouble. Learn more at advocacydenver.org. Thank you.